All right, sorry for the break. All right.
We can't hear you, sir.
We can't hear you.
I hear you.
Said.
Thank you.
So, courts of records and courts other than courts of records. So, I said formally a court of records was a court which kept a record of its acts and judicial proceedings, and also possesses the power to punish for contempt. Today, the only essential feature of a court of records is its power to punish for contempt. So unlike what it used to be, the yardstick for determining which court is a court of record and the one that is not a court of record was simply by asking
We can't hear you, sir.
No, she said the man don't come out. See the man for you.
but we still have to move on. Okay. So I'll continue. A court of record may be a superior court of record, maybe a superior court or an inferior court. The underlying factor as to what can establish whether or not the court is a court of record is its power to punish for content. So that's why the argument that a court of record is a superior court of record or an inferior court. For example, the magistrate court, even though an inferior court of record has power to charge a person on a charge of content when the offense was committed out of
Sir,
court,
we can barely hear you.
also to impose punishment, but cannot punish the offender in absence of the charge.
Let us break it up. We can't hear you.
The charge is a formal complaint or information brought before the court regarding an allegation of crime. And the thing on that is that the magistrate
We
court
can't hear you, sir.
and the inferior court of record will settle the power to charge a person on the charge of contempt when the offense was committed out of court, and power to impose punishment but cannot punish the offender in the absence of the charge. And I said the charge, which some of us will know, is that formal information stating what an alleged person has done. And hello, back.
Excuse me, sir. We can barely hear you. We can barely hear you. We've been trying
We
to
can
call your
barely hear
attention
you.
since.
Hello?
Yeah.
Hello, can you hear me?
Yes, sir. It's better now.
Okay, all right. So, having said that, we now also look at, to be specific, we will now focus on courts of record. Then thereafter, we will examine courts other than courts of record and the various characteristics that we need to establish on them. So for a court of records, it's just a legal term referring to a court where the proceedings are permanently recorded and preserved for future reference. Now, when we talk about proceedings, we talk about the business of the day in each case or in the court. When parties bring argument, they bring different facts, sometimes they bring evidence, a lot of things happen, but the court is duty bound to take record of the proceedings, of the actual handling of the case. So, a court of records refers to that court that usually preserve the record of its proceedings for future reference. And if we say for future reference, what will come to mind is what is the purpose? And I believe when we're dealing with different courts, I'll talk about the highest courts, followed by the Court of Appeal and all of that. we did say that the decision of lower courts are not usually, they are not final, because the court is not a court that can put a total seal on whatever issue is before the court. Meaning that the parties to the suit or to the case, as you popularly call it, may want to appeal the case to another court or to an higher court, probably because he or she is not satisfied with the outcome of that meeting, of the courts. So, and when a case is appealed against, the court over there does not deal with abstract situation. The court will look at the record of the lower court that had the matter before them. And when that is done, it will aid the court to properly review the case that is before it. And when that is done, the court is now able to take decisions that will benefit both parties in the interest of justice. But before that court, higher court can successfully review what is before it, there must be a record of what transpired at the lower court. So that is why we're saying that the courts preserve its record for future reference. So the superior court, a court of records, maintain an official record of all the actions, even the testimonies that the litigant present to court. So also the evidence presented during trial or during the hearing of the case. So this particular record that they keep serve as an authoritative account of what transpired in the courtroom and is typically used for appellate review or other legal purposes. So the record, it's like a minute of a meeting, even though it's not strictly so, but it's a resemblance just to make us understand the message that we're trying to pass across. So it's the record, and that is what is used up there when a case is to be reviewed. So courts of record provide transparency and accountability in the justice system by ensuring that a detailed and accurate record of proceedings is available for reference. Of course, it is believed that if the proceedings are recorded, the actual happenings in the court will have been recorded, meaning that there is nothing to hide. And then if a neutral body is to look at that record, in reviewing what is there, they will be able to arrive at a fair decision. So that is one of the major reasons why the records are kept. Now, what are the examples of courts that we can refer to as courts of record? The first one is the Supreme Court. Of course, I know by now, you know that it is the highest court in the land. The Supreme Court, followed by the Courts of Appeal, High Court, and Federal High Court. And these three courts that I've mentioned, even including the Supreme Court, are also referred to as appellate courts. I remember stressing this in the course of our last class, that for the reason that they has received appeal from lower courts, they are referred to as appellate courts. So therefore, in simple terms, examples of court of record include the Supreme Court, the Court of Appeal, High Court, and Federal High Court. Now, let's move forward to look at non-courts of records. Non-courts of records are also known as a court not of record. Because if you see it anywhere, don't get confused that, oh, it is not, since it was not called a non-court of record, then it is not it. But what we are saying is that it can be also referred to as court not of record. Device, kindly mute your device. So, court, a non-court of record is a legal term referring to a judicial tribunal where the proceedings are not permanently recorded or preserved, as in the case of the Superior Court or Court of Record that we have looked at earlier on. So, in these courts, the decisions and proceedings are often informal, meaning that they are not in any way recorded. Okay? They are informal in that, probably because they are lower courts, they make their proceedings much, much simpler in order to give room for every member of the society to have access. So, like I said, the decisions and proceedings are often informal, and there's no requirement to maintain a detailed record of the hearing. Non-court of record are typically used for handling minor legal matters, such as small claims or administrative hearings, or even small violation cases. Violation cases mean traffic violation and all those offenses that can be classified or tagged minor offenses. But this court, that is the non-court of record, unlike court of record, the decision made here are usually subject to appellate review based on a formal record of proceedings. Okay? The decisions, like I said, because they are inferior court, their decisions are not final. And again, their proceedings are not expected all the time to be so formal. And they are also not expected to maintain that record of their activities or hearing. So usually the non-court of records rely on the judge's notes or any transcript created if requested by a party involved in the suit. But mind you, the fact that we have submitted that this court is not are required to at all costs maintain the record of the activities, the judges still take their notes. And these notes, in a way, also form like a record of the court, but not in the way that the court of record will maintain such proceedings or records. So it is not outrightly so that they do not have anything to show, but that is limited to the records or the notes that the magistrates or the judges in those courts make while the action is ongoing. So, examples of non-court of records include traffic courts, small claims courts, administrative hearing, and magistrate courts. These are the examples of the courts, non-courts of record. Now, for better understanding, there is need for us to look at the key differences between court of record and non-court of records. These differences include the following. They are not limited. Odutayo.
Yes, sir. Good morning, sir.
Yeah, please go ahead.
I have a question. Can customary courts also be a non-court of record since the laws are unwritten?
Yes, customary court is part of these courts that we are discussing. But it's not a matter of whether their laws are written or not. But it is a matter of whether there is a formal preservation of the proceedings of the court. But usually when we classify court, we talk about superior court, we don't mention customary court. Rather, we mention customary court under the inferior courts. Do you understand now?
Yes, sir. Thank you, sir.
Okay, so the key differences include number one, the level of formality. At the non-court of records, the level of formality is very low. They don't adhere strictly to all the rules that the court of records, maintain. Now, the reason for that is simply flexibility, and because the cases that come before it are not cases that are so complex that cannot be amicably resolved. Okay, so their level of formality is very, is lower than the court of record. Number two is that the power to fine or imprison is also limited. For example, if any of them want to fine someone, they have a certain limit to which they can impose a fine. But unlike the court of records, there's no limitation. Once the said matter is properly before the court possesses enormous power to deal with the cases as they come. But it is not so with the non-court of record, because they also have limitation as to the award they can give, the fine they can impose, and also the term of imprisonment that they can impose. The third one is the maintenance of a permanent record. Like we have established in the course of our explanation, they do not maintain permanent record. What we see mainly are the judge's notes. Okay? So that forms one of the major differences. And the last but not the least here is the ability to appeal decision. The decisions reached by this court are oftentimes subject to appeal. But when you look at the Supreme Court as a court of record, any decision given at that court is final and cannot be appealed against. And that is simply because the Supreme Court is the highest court in the land and also a court of record for that matter. So note that courts of record are typically more formal and have more significant powers, while non-court of record are less formal and have more limited power. So the power they possess is a way of measurement. That is the power limited in any form or it's not limited? These are the points to note when we are discussing these two courts. Again, I will look at the key differences. We can also look at the similarities between these two courts. This court maintains some similarities, and the similarity is that they are both types of judicial courts where legal matters are adjudicated upon. So the question is not whether they are court of record or not, but they attend to cases presented to them by the litigants. So that's a major similarity. We will not go as to whether or not the said court is inferior or not, but both of them are, first of all, judicial courts recognized by law of Nigeria. Another similarity is that they both have the authority to hear and decide cases within their jurisdiction. So whether what they can adjudicate on, whether the kind of fine they can give is not the same, but they have that power in them to give or impose a fine because they constitute courts before the law. So the similarity is that they both have laws. Additionally, both types of court aim to administer justice. So we can also take that as a third major difference between these two courts, that is, courts of records and non-courts of records. So they administer justice according to the law and ensure that fairness is done or is seen or equity prevail, in there. So they ensure that there is fairness in their proceedings, irrespective of the level of their formality. So those three major points are major similarities between the courts under reference. In conclusion, on this court of record and non-court of record are essential components of the Nigerian legal system. So they said the classification does not take away the fact they are essential components of the Nigerian legal system. And each of them serve their distinct complementary roles in administering justice and also in resolving disputes. While court of record provides a formal framework for documenting legal proceedings and ensuring transparency and accountability, the other one, which is the non-court of record, offers flexible and community-oriented mechanism for resolving disputes in accordance with local customs and tradition. So, whichever way, both of them indeed possesses the power to do justice. But by understanding the strength and limitation of both systems, legal practitioner, policymaker, even students like you can work towards building a more accessible, inclusive, and effective justice system in Nigeria. Lastly, if these two courts don't exist, then we do not have a legal system indeed. So with that, we come to the end of the topic on courts of record and courts other than courts of record. So we take on the next classification, which is court of limited and unlimited jurisdiction. Courts of limited and unlimited jurisdiction. So the first thing we need to ask regarding this topic is, what is jurisdiction? Okay, what is jurisdiction? Jurisdiction, when we look at the word juris from Latin, it means law. Why dictio, that is D-I-C-T-O, which like the other parts of the word of jurisdiction, it means a speech or declaration. So therefore, jurisdiction is a legal term for the legal authority granted to a legal entity to enact justice. I'll repeat that again for purposes of emphasis, that this jurisdiction we're talking about is a legal term for the legal authority granted to a legal entity to enact justice. Now, who or what is a legal entity we are talking about here? We simply refer to the court because, of course, it is the court of the land that has power, possesses the power to administer justice to the citizen that may come before it. So, in federation like our own, Nigeria, the concept of jurisdiction applies at multiple levels, e.g., the local, state, and also the federal. And that's why later on we will see that we have federal courts, we have state courts, and courts that appears to fall under the local government by virtue of what they deal on. Okay, so it can also mean authority by which judicial officers take cognizance of and decide cases. That is another definition that can be given to jurisdiction as a subject. So it refers to power for a court to hear a matter. Then the next thing we're going to ask is that, are there different types of jurisdiction? The answer is yes. We have three major types of jurisdiction. The first one is original jurisdiction. The second is concurrent jurisdiction. And the last one is the appellate jurisdiction. The appellate jurisdiction. Now, we'll take them one after the other for purposes of emphasis. Original jurisdiction grants authority of a court to hear a case for the first time. If, for example, you, a landlord, you have an issue with your tenant, it is not just anywhere you can take such matters to, that we have the backing of law. If you want the law to be involved, you have to take it to an establishment, an entity which the law has created, which is usually the court. And the court where this matter or this case is first heard is what we say that the court has original jurisdiction. On the second one, which is concurrent jurisdiction, we talk about jurisdiction in which that may be exercised by two or more courts over the same matter. Okay? Where there are existence of two or more courts that can adjudicate or exercise its power on a particular matter. Meaning that outside where it starts, another jurisdiction is the one that may be exercised by two or more courts. While some is only limited to them alone, others can be limited to two different courts. And the third jurisdiction is appellate jurisdiction. This is the jurisdiction that allows a court to hear a case that has already been decided on in a lower court. Okay? That is what we mean by appellate jurisdiction. So it is also a means in which a superior court is invested with the legal power to correct, if it so decide, legal errors made in the lower court. So, appellate court receives appeal from the lower court, that is the court underneath it, and they have the power to undo. They have the power to review also. They even have the power to overrule whatever decision that lower court has made, depending on the argument that is before the appellate court. But basically speaking, we are saying that the appellate jurisdiction invests in the other court, that is the higher court, the authority to decide legal errors made in the lower court. Typically, and for example, the Supreme Court has appellate jurisdiction over cases, as most cases that come before the Supreme Court have already been decided in a lower court. But that does not mean that the Supreme Court does not have cases that start afresh before it. But those are cases that the Constitution has provided for, and which is mostly when there is conflict between states. Okay, the matter can start off from the Supreme Court, but usually what we are saying is that matters do not usually start at the Supreme Court. The Supreme Court usually accepts appeal from the lower court, which can be Court of Appeal, it can be Federal High Court, it can be High Court of any state, it can even be High Court of the Federal Capital Territory. So that's what we mean by the concurrent jurisdiction. Now, there are two types of court under this classification, which is what we are looking at, that is court of limited jurisdiction and court of unlimited jurisdiction. No, let's look at the definition of court of unlimited jurisdiction now. So the definition is simply court of limited jurisdiction, also known as inferior court, are courts that have restricted authority and power to hear and decide cases. And they are typically low-level courts that are authorized to handle specific type of cases. So like I mentioned earlier, minor crime, small claims, and also family matter, maybe as it relates to child support or even temporary child custody. Okay, so those are the examples, like we said. So, and these criminal offenses may include traffic violation, misdemeanor, while small claim may be civil cases involving limited amount of money, not so huge an amount of money that will not allow the magistrate court to have the power to hear it. Examples of courts that have limited jurisdiction. Number one is the magistrate court. Number two is the small claims court. Number three is the area court. Number four is customary law court. And last but not the least, we have family courts. Okay, all of these are different examples of courts that have limited jurisdiction. Now, another thing we need to note about this is What are the features of limited jurisdiction? The features simply include that they are usually subject to the supervisory jurisdiction of the High Court, meaning that their decisions are not final. Another feature of limited jurisdiction is they have jurisdiction, over a specific geographical area, such as states, local government, and districts. Okay, meaning that they are limited by geographical space. Also, they have authority over cases involving limited amount of money, typically up to a specified amount. Number 4 is that they prioritize dispute resolution and settlement over complex legal argument. Instead of engaging in series of legal arguments or legal battles, this court prioritizes dispute resolution, how matters can easily be resolved rather than going to court for 20 years, for 30 years. Also, they handle cases quickly and efficiently. Okay, these courts handle cases quickly and efficiently. And that point may not be far from the angle that they are less complex. They cannot say, because you did not serve us at so time, therefore, whatever it is that you have served us is not valid. Or they engage series of evidential rules to frustrate the proceedings. That does not happen under the court of limited jurisdiction. So they provide faster resolution of dispute. And number 5, dispute resolution and settlement is prioritized, promoting quicker and more amicable solutions. But what are the shortcomings of court of limited jurisdiction? They are as follows. Number 1, they have limited authority to impose sentences and grant remedies. They are not able to do that as they desire. Number 2 is that they are restricted in the type of cases they can hear and the monetary limits. Number 3 is that decision made in this court may have limited option for appeal, potentially depriving the parties of the opportunity to have their case reviewed by a higher court if they believe an error has occurred. Because the court of law, the judges sitting in the court of law are not God, so they can actually also make mistakes. So, but we also say that despite their efficiency, this court may still be overwhelmed by a lot of cases. Okay? Now, that is for the court of limited jurisdiction. Before we close, let's look at the definition of court of unlimited jurisdiction. So, court of unlimited jurisdiction are courts that do not have jurisdictional limits, meaning that they can attend to any case provided they are properly filed. Okay? So regardless of the subject property, the remedies, they are able to attend to them. They are typically high-level courts or higher-level courts And it's important to note that no court in Nigeria has total unlimited jurisdiction, even though we are saying this court possesses unlimited jurisdiction. The reason why we describe them in like that is because the limit they have is very minimal. So provided they do something according to law, they do not really have, what we say limits. What are the examples of courts of unlimited jurisdiction? Number one is the Supreme Court of Nigeria, followed by the Court of Appeal, followed by High Court of a state, followed by Federal High Court, High Court of the Federal Capital Territory, last but not the least, National Industrial Court. These are examples of court that falls under the Superior Court. Now, what are the features of this particular type of court? They have the authority to hear and determine any type of case without restriction or limitation. And unlike the inferior court or court not of record, they have jurisdiction over the entire country or the state where they are. So they are not limited as such. Then the decision of the Supreme Court as a court of unlimited jurisdiction in all cases is final and binding. And they are not subject in any way to any review, because that is the highest court in the land. Okay, so we look at number 5. It says that they have the authority to grant any remedy or reliefs, including damages, injunction, and declarations. So they possess that power. This court of unlimited jurisdiction, they have benefit. What are these benefits? Number 1, they provide comprehensive justice because they handle complex matter. They are able to deal with those cases and provide comprehensive justice. So, therefore, the court provide comprehensive justice. Another point is that due to the binding nature of their decisions, they provide certainty and closure for parties. They provide certainty and closure for parties. There is usually a way of making a case to have a good end, especially when you go to the Supreme Court. You can be sure that the court will have done a comprehensive justice on the case before it, and then people will say whatever comes out of it, I accept. Okay. Another benefit is that presence of expert judges to handle cases involving multiple parties. The judges that are in those courts, High Court, Court of Appeal, and Supreme Court, they are judges that have spent years in doing this work, and they've known a lot relating to it. So they are able to use their expertise to ensure that justice is done. Number 4 is that they can efficiently resolve complex cases because of their level of knowledge. And the last point on this is shortcomings of courts of unlimited jurisdiction. What are the shortcomings? Number one is that litigation in courts of unlimited jurisdiction can be expensive, as cases often require complex legal representation. That's why sometimes you see plenty lawyer representing one person. But one thing you can know is that is going to pay, this litigant is going to pay those plenty of lawyers, or if he has paid their leader, that leader will also factor the fact that these people are also entitled to have some benefit. So number two is that they are not infallible, and they can make error or decisions in their court, in their judgment. You can't say that they cannot make mistake. Then number three is that they can be swamped with cases. That is, they can be overwhelmed with cases. And number four is that they often have complex procedure and formalities. There is no way you can do any of your cases or matter there without adhering to the rules of court. They are so important. And then number five, which is the last, they may be located in distant locations, making it difficult for parties from remote areas to access justice. So these are the shortcomings attached to the unlimited jurisdiction. So having taken these two topics, which include the court of record and court of no record, and limit court of record and unlimited jurisdiction, we would like to bring the class to a close now, so that when we resume and meet next time, by God's grace, we will talk on English court and non-English court. So do we have any question before we call it a day? Any question?
Good morning, sir.
Yeah, good morning, Mercy.
So the question is not about today's lecture. I'm just confused as to what the course code is, because I made direct entry in 300 level. So it appears the course code in the portal, because I already registered, is different from what I heard one of the year one students say. Course code is.
You are in 300 level?
Yes, sir.
You are coming in as a direct entry at 300 level?
No, I started in 200. So but I'm taking the course in 300 level. I didn't take it in 200 level.
And ask the current 200 level student to show you the course code they are using, or you discuss with your coordinator, and then you can look at their course form, you identify the correct course code. Okay?
Okay, sir.
All right. So thank you very much all for listening.
Sir, sorry,
Yes.
sir. Good morning,
Yes,
sir.
please. Good morning.
Sir, you gave us benefit for court of unlimited jurisdiction. Is it like there's no benefit for it in the court of limited jurisdiction?
Court of limited,
Can you hear
where
me?
there's no benefit. You're asking if there are no benefit for court of limited jurisdiction?
Yes,
We
because you gave
discussed
us the benefits. You
We-
didn't mention, you mentioned shortcomings, but not benefit for it. But you did it for unlimited. You mentioned benefit for unlimited.
No, we discussed that. We discussed about 5 points. Maybe you were not, your mind wasn't here, or you were locked out, kind of. So if you listen to the recordings again, you will see the benefit there. So the recordings are on the YouTube platform, and you can listen to them. As a matter of fact, you are encouraged to always listen to the lectures, at least at your leisure time when you are relaxing, you just play them. All right, so thank you very much. Do enjoy the rest of your day. Bye-bye.